Well, good morning, everybody. Thank you for joining today's seminar on coming out of lockdown. We're delighted to have you all join us today. Can I ask, for those of you that haven't, or for those of you that have been on these sessions before, you'll have heard us say this countless times. Those of you that haven't, can I ask that you just remain on mute throughout the session, please, just to stop any background noise. And if you've got any questions at all, if you just want to pop them in the comments section, then we can try and pick up as many of them as we can as we go through the session. My goodness, a lot is changing, and it's changing very quickly, isn't it? Since the start of March, we've been focusing really on legal issues that arise as a result of going into lockdown. And obviously that focus is shifting very rapidly now to the legal issues that we need to be aware of as we move towards a gradual lifting of lockdown. You'll all, of course, have seen the government announcements over the weekend and yesterday. And some of you might even have read the 60-page document that was published yesterday covering various issues around about the easing of lockdown. And clearly there's a real issue between the differences in Scotland and Wales and Northern Ireland compared to England. So lots of issues there. For the purpose of today's session, we're going to start looking at some of the kind of legal issues that businesses and organisations should be starting to focus on if they haven't already in relation to that easing of lockdown. The kind of key focus of this session will be health and safety issues. That's obviously very important. That will be covered at the beginning of the session, and then my colleague Jen and the employment team is going to cover some of the employment issues at the end of the session. In between that, we're also going to look at supply chain issues, issues around about data privacy, product liability, property and construction. So there's a lot to cover. So I'll start, if I can move on and ask Lynn to pick up on some of the health and safety issues. Lynn, I know obviously health and safety is absolutely in the spotlight as the country looks to gradually return to work. So what are the key issues that organisations really should be thinking about at this stage in your view?
Yeah, thanks, Morag. It is very much a bit of a hot topic at the moment. Obviously, protecting the health and safety of employees at work must be paramount. That's always been the case. As an unprecedented public health emergency, coronavirus has really left businesses struggling to comply with their legal obligations, and with the guidance changing almost daily, and now with regional variations coming into the fold, lots of people are really left with their heads spinning in terms of compliance. It's fair to say that this is just the beginning of what is going to be, I think, a gradual and potentially messy coming out of lockdown. This morning, I'm going to touch on some of the key issues about health and safety, some practical the view to...
Lynn, sorry, can I just interrupt you just for a moment?
Sure.
Could everybody else just put themselves on mute? There's quite a bit of background noise. If I could ask everybody to put themselves on mute, that would be great. Thank you.
Thanks, Morag. Yeah, I think it's going to be a potentially messy coming out of this lockdown, but today we really want to give some practical considerations and really start thinking about exit strategies for when furlough ends and some planning. It's worth just reflecting on the legal position at the start in relation to health and safety, because obviously the legal duties which have always applied continue to apply in this situation. We have new coronavirus legislation and public health guidance which operates in addition to health and safety duties which are incumbent on employers, I should say, including the general legal duty to take all reasonably practicable steps to ensure the health and safety and welfare at work of all employees. And that duty extends to protecting others who might be affected by your work activities, including contractors and the general public. So that could include visitors to your business or a site or customers who come in to use your business and your services. Now, the health and safety duties are onerous on employers, and there are legal risks associated with non-compliance. There's effectively it's criminal offences for failure to comply. Business disruption is also likely if there's enforcement activity, because under the new coronavirus legislation, the police and local authorities can potentially shut down your business. The health and safety executive have that option in addition to prohibition notices, something that I'm sure all employers are familiar with and aware of. reputational damage is also a huge factor potentially at the moment because of all the sensitive issues around coronavirus and the high publicity that runs alongside that. It's worth pointing out that there's also the potential for individual liability in addition to corporate liability for health and safety failings. And I would stress that these are criminal offences. For individuals, there's the risk of imprisonment in relation to health and safety failings. So these are serious issues and they're not without risk for businesses. Because of the health and safety duties which are incumbent on employers, and if an employer does not think it is safe, then they're not obliged to resume operations, and indeed doing so would be tantamount to a criminal offence. The regulatory framework across the UK is virtually identical at the moment in relation to the coronavirus restrictions. The restrictions put in place back in March were reviewed last week. That led to one minor change for Scotland in relation to the ability to exercise. Other changes which have been extensively reported, and as Morag alluded to, the 60-page document which was issued in England yesterday, those changes apply to England and not to other parts of the UK. So it's important to look at what has not changed, and I would say yet, because we're all anticipating change to come. But at the moment, the law on who must work from home has not changed. The law on who may go to work has not changed. The law on which businesses must remain closed is not changing. And most importantly, the law on health and safety at work, which is UK-wide, has not changed. The furlough scheme remains open at present, and we are expecting an update on that today, and I'm sure Jen will touch on that. But the messaging which is coming out across the UK is that we should all expect, a gradual change, whether that's at the same pace across the country or not. It remains to be seen, but it's likely that certainly England will lead the way for the UK at the moment. But the change is expected to be gradual rather than falling off a cliff. So the key at the moment is to be prepared, and wherever you are located, and that's whether you're in Scotland or England, Wales or Northern Ireland, is to stay alert to the changes in guidance, because you're required to ensure that you comply with the guidance to ensure compliance with your legal duties. England is now actively encouraging a return to work, where Scotland is taking a much more cautious approach at the moment. And that actively encouraging a return to work is where working at home is not possible. I expect that if you can work from home, then that will be the norm and the safe option going forward for a considerable period of time. All workplaces must continue to follow relevant national and global guidance which is in place. So that's the guidance which is coming out of the UK government, the Scottish government, and also the World Health Organization and other global guidance which may be relevant. Essentially, in looking at coming out of lockdown, comprehensive risk assessment is going to be key. The guidance which is in place, which you're required to follow, is designed to help you comply with your legal duties. That guidance is not law, but any deviation from the guidance will require to be supported by a robust risk assessment, because for employers, you have to ensure that your workplace is safe and that the health and safety of your workforce is maintained, and that has to be paramount. So going forward, gaining the trust and support of your workforce and indeed your customers for your business is going to be key. So the main steps that you need to be thinking about in coming out of lockdown should centre around that early and transparent communication with your employees. If you've not already started talking to employees and making your plans about coming out of lockdown, it's worth doing that now. Boris Johnson yesterday sort of retracted slightly in the way he was approaching the actively encouraging people back to work, and it really is around a discussion about how people can actually get back to work and do so safely. The For employers, that includes thinking about guidance that may be issued to employees, any protocols that may need to be put in place, and you need to think about how you're going to communicate with your employees on that, whether that may be through email, video, or online training, which may take resources and it may take time. So while there may be a desire to return to work and an option to do that safely and legally, it will take time to have those plans put in place. And if you have employees on furlough, it could potentially prolong that process or make it, different arrangements have to be put in place to take account of that. And Jem will probably consider that in her chat at the end of this session. If you recognise a trade union through your business, then early engagement with that trade union should help ensure understanding and support for your plans. I know that the trade unions are keen to have a more active and formal process put in place around risk assessments to ensure safety in the workplace, and that's something that you need to keep abreast of and be aware of. Particularly where you have any trade union engagement with your business. It's something that you need to get the trade unions on board and with you. There's numerous other aspects of the workplace and also your employees that will need to be considered in managing safety and managing a safe return to work. The risk assessment should inform those areas, but some of the key aspects may be PPE. You'll have to consider both the requirements for PPE in relation to your work activities and the availability of PPE. It may not be possible at the moment to source that if you're a business that has not been required to use certain aspects of PPE before coronavirus came to the fore. Shift patterns and movement of employees will be key to ensuring compliance with social distancing. Access and egress to the workplace will be important, and that may be complicated where you are in a multiple occupancy building or you don't have control over certain aspects of access and egress to your workplace. Toilets, kitchens, communal areas, including gyms, which may have contractual obligations if they're sourced externally, all have to have additional measures put in place to ensure safety and that the risks of coronavirus are addressed. Meetings and travel for business may be curtailed for some time and may no longer be necessary at the moment or possible given the risks presented with coronavirus. There will be third-party risks in accessing the workplace, whether that's contractors or customers, and we're aware various industries are looking at some different options and mitigation measures to control the risks in relation to that. First aiders and fire marshals and any requirements around fire safety will have to be considered, bearing in mind the restrictions and social distancing requirements which are now and remain in place and are legally required to ensure safety and control the risks associated with the virus. Before you start work, you will also need to check whether or not there are any statutory inspections which are required and may still be required despite the coronavirus restrictions being in place. And you may need to make sure if your business hasn't been operational throughout this lockdown period, if there are inspections which have lapsed, which will require to be undertaken before you can safely bring people back into the workplace. And again, that may take time. So this is really a huge planning exercise around risk assessment and road mapping, how you can come out of lockdown and bring people safely back into the workplace.
Just on that, Lynn, from the conversations that you're having with clients, how keen are they to kind of reopen and get going? Is there an anxiety there, or is there a real push to try and get things moving as quickly as possible? What sense are you picking up from the conversations that you're having?
Well, certainly the clients that are approaching us are acutely aware of their health and safety obligations and their duties, and they recognise that the health and safety of their workforce is paramount. I think they're keen to ensure that if they can get back to work, they do that safely, and it's understanding the legal duties that sit alongside, a desire to get back to some sort of normal. I think everyone recognises that this situation, the lockdown that we're in, cannot go on indefinitely. It's not sustainable, but equally the onerous health and safety duties that are on employers are not relaxed, and they're very, very important in the grave, given the grave nature of the virus and the implications for failings in safety around that. So we're seeing a desire to get it right, I think, is the real aspect here. No one is taking the situation lightly, and no one is pushing ahead and putting profits before safety. It's certainly very much a huge exercise in trying to get it right and complying with our legal duties, but it's not easy. That's the main thing at the moment.
It certainly seems tough. And what about I suppose you'll have businesses that have operations in the north, and in Scotland you'll have businesses that have operations in England as well. How do they approach the sort of different guidance then between the two countries?
The difference in approach is not helping the situation, I think, where there's different messages. But obviously, if your business is based in one jurisdiction or more than one jurisdiction, where your business is located, you have to comply with the laws and the regulation of the relevant jurisdiction for that particular part of your business. Where it gets complicated is if you at the moment, for example, if you're running a business north and south of the border, there are different guidance that may apply. Scots law is not subservient to English law. Any business will have to make sure that they comply with the regulations relevant to their jurisdiction, the UK-wide health and safety duties, and the guidance which is in place, which is designed to ensure compliance. Now, where there's divergent guidance, the more stringent guidance is the one that will be expected to be followed. That may mean that you have a situation where some businesses, for example, in construction, I'm aware down in England and Wales, have been operating when other parts of the businesses in Scotland have not been able to, and that is a difficult decision. If you are choosing to diverge from that guidance, which, as I said, is not law unless it's mandatory, then you would have to support any decision with a robust risk assessment. And that's why, for any business leading the way out of this lockdown, it really depends on strong leadership, which is informed and is making assured decisions to ensure that they comply with the legal duties. Because, failing to do so, there is enforcement tools which the health and safety executive, the police now, and others can use to take enforcement against businesses with significant fines, and the reputational risks are potentially greater at this stage.
If I can move on to David. David's a partner in our commercial contracts and technology team, and David, I know you've been dealing with a lot of issues around about supply chain as we went into lockdown. Is the focus of that kind of advice started to shift now as we're looking at coming out of lockdown?
I think hi, can you hear me okay?
Yes, I'm delighted to say I can.
Well, yeah, just picking up on just the point about the conversation there, I think as Laura Koonsberg was saying last night, the bonds between the four nations are being stretched. I think Scotland, Wales and Northern Ireland are sticking with the stay-at-home mantra, and England is moving ahead with stay alert and return to work when you can't work from home. And I think that will create a number of inconsistencies and challenges for businesses that operate in different parts of the UK, and for the suppliers who are part of the supply chain that work with those businesses as well. So, for instance, what if your business operates in England and is looking to a Scottish-based supplier to now turn back on the supply tap, and the Scottish-based supplier may not be in a position to do that? Or the other way around, if you're a supplier in England that wants to supply to customers in Scotland, and customers in Scotland are not perhaps in a position to make full use of supplies. So there's a number of different supply chain related issues I think we're seeing from the different approach across the UK. I suppose regardless of whether you're a customer or a supplier, there are a few things from a supply chain perspective you may wish to consider. So it's probably time to review your existing contract estate and just to understand whether they are still working for you and delivering value. For instance, quite a number of supply contracts may contain restrictions on your ability to contract with others, or they may contain some onerous provisions. And when a lot of our clients are looking at onboarding new suppliers for one reason or another at the moment. And I think it's important to try not to fall into the same traps that we've seen with some of the contract issues when we're coming into lockdown. So I think it's important in that situation, when you're onboarding new suppliers, to conduct and undertake proper due diligence. In other words, to make sure you pick the right partner. I think when entering into any new relationship, you need to understand who you're dealing with, their commercial, operational, and logistical strengths and weaknesses, or lesser strengths, as it's sometimes referred to. Pay attention to the key risks for your business. Key risks is obviously the most important thing. And who will bear the financial or commercial exposure if these risks materialize? If you bear the risk, and sometimes in contracts you have to take it in the chin, do you have insurance in place that will cover those risks, or do you have a plan B? And the sorts of key risks that we're seeing a lot of, both coming into lockdown and now, is things like force majeure clauses, whether parties can cease undertaking obligations because of issues, termination rights, how do you get out, exclusivity provisions, liability provisions, resolving disputes, how do you go about resolving disputes in the situation, and remediating issues as well. So these are some of the sorts of supply issues that we're seeing at the moment.
Okay, so there's a lot there, and I suppose the other issue that comes to mind for me is data privacy. I'm conscious, it looks like people who can work from home are going to be asked to work from home for quite a period of time. I know every time I leave my desk, I still lock my keyboard and shut my book in case any neighbours look in the window. But yeah, I mean, I imagine there's a lot of issues there to be thinking about as well from an employer's perspective.
Yeah, absolutely. And whilst this is an area that's not been expressly mentioned as part of the latest government briefings, data privacy and cyber risks are both extremely important, obviously, for most businesses and organisations. The ICO, which is the UK data regulator, has indicated that it's still business as usual as far as they're concerned, albeit they do recognise the unique challenges that all businesses are facing at the moment. So they've indicated that their main priorities are to protect the public interest, particularly vulnerable citizens, to enabling responsible data sharing. There's a lot more data being shared at the moment, and to monitor intrusive and disruptive technologies. So basically protecting privacy while enabling innovation. And there's obviously been a lot of chat in the press recently about the NHS Tracker app and the potential privacy issues surrounding some of that. I think in the last 8 weeks, with the majority of the working population working from home, and many likely to continue for a considerable period of time in the future, new working from home arrangements have brought about new issues that haven't really been thought about. So I think it's fair to say that due to the speed of change and the agile way in which businesses are approaching the new challenges, a lot of these risks from a data privacy perspective probably haven't been adequately understood, known, mitigated, or managed. So I think now where we are, I think we need to now think about what are those risks. Are they properly understood within businesses? So I would urge all businesses to spend some time to consider and carefully address these things. For instance, we're all using WebEx and lots of different new technologies and systems and engaging new suppliers. And have data privacy impact assessments been carried out when onboarding these new systems? That's a requirement under GDPR where a supplier or system touches on personal data. And I think a lot of businesses, organisations probably haven't done the due diligence just because of the way that everything's moving at such a pace. And the other thing is, do you know where your data is now residing or being held? whether it be third-party systems or whatever else. Again, a data map and data audit is another requirement of GDPR to understand where your data is being held. And the final thing is, we've all got our GDPR policies and working from home policy and all these various things, but are they fit for purpose now? Do they need to be reviewed so that employees are very clear about what they can and cannot do in the new norm, the working from home environment? So there's loads of different things for employers to think about there.
Yeah, I think there's definitely an issue about people, as you say, being asked to work from home very quickly and suddenly, and those issues have not necessarily been particularly covered in any detail, but I guess the emphasis will be to start looking at that a bit more now, as things settle down to the extent that they can, you know.
That's right, yeah. This is the time.
Yeah. I'm going to hand over to Joanna now if I can. So Joanna's a partner in our commercial disputes team. And Joanna, I know that you've obviously been dealing, kind of similar to David, you've been dealing with supply chain issues in terms of going into lockdown. What's the situation if you've kind of entered into a dispute with a supplier and you're now looking to come out of lockdown? Can you still keep working with that supplier as you move forward now?
Yeah, thanks, Morag. Well, I mean, the short answer to that is yes. I think trust and those old relationships will be really important coming out of lockdown to enable the business to get back up to speed as quickly as possible. So it shouldn't be a case that you feel you need to change supplier because you've got a potential issue with them in relation to, for instance, payment or something that they were supposed to provide and haven't provided. Also, that would apply if you've got a customer of yours and you may be somewhere in the middle of the supply chain and you've got a customer issue as well. I mean, basically, yes, you can keep dealing with them. What you just need to be careful about is what you are telling them about any dispute, payment issue or whatever that you might have with them. I think the key thing is that you don't give them you don't infer that they are let off the hook somehow, that you don't provide them with so much comfort that they can basically come back and say at some later point that they understood that they were essentially being let off the payment or other issue that you had with them. So you need to be careful what you're saying or doing doesn't essentially infer or waive your right to take action at some point in the future. So I think really the key is to just highlight to them that is an issue that remains live for you, that you're happy to park it in order for supplies to keep moving. You want to still engage with them, but that issue will need to be addressed at some point, and it still remains a live one. And it's not, and you're not essentially allowing them to evade essentially what they're supposed to be doing. So I think yes, that is possible. I guess that the next question is, if you don't think it's possible, you don't think the relationship can keep going, can you terminate the contract? We've been giving lots of advice to people about possible right to terminate their contract. Either a supplier or customer can't deliver what they're supposed to be doing, or for some reason the relationship's not going to work for the future. They may not be around. They may have issues themselves and they're not delivering to you, and so on. So there are options in relation to termination. Some of that depends on whether you've got a written contract. You won't always have a written contract, but if you've got a written contract, you should check whether there's a notice provision. You may be able to literally terminate on notice. You just got to be careful to comply with precisely what is required by the contract. Even if it doesn't have a notice provision, you may be able to you should be able also to terminate on notice. How much time you need to give will be dependent on the circumstances, so there's no hard and fast rule, but certainly giving a reasonable notice period would be safest. But those may not be the quickest route to termination. It may be if you can say that they have done something which they weren't supposed to do or not performed some obligation, payment being an obvious one, then you may be able to say that they have essentially breached the contract and you may be able to terminate on that basis. Another one which people will have heard being bandied about is this concept of a force majeure clause, which some force majeure clauses may allow you to terminate in the current circumstances, but they're all very different in terms of their wording. Some may allow you to terminate, some may not. Some may only allow the other party to terminate and not yourself, so you need to look at that. You'll probably need somebody else to look at that clause to tell you whether you're able to terminate. And last but not least, probably worth just highlighting that there in any written contract, there will normally be provisions about how you provide notice, and you should make sure, as I say, that you're complying with those formalities, because these little things, pedantic though they may seem, may come back to haunt you at some later point. And I was on a webinar with a very senior judge last week down in England who said that she predicted there was going to be a lot of disputes about these kind of notice provisions over the coming months, rather lawyerish though they may sound. I mean, it may be worth just commenting on escalating, because a lot of people are concerned about when the right time is to escalate an issue with a customer or supplier. You know, I've got this ongoing relationship, I'm just worried about when the right time is. I think from our perspective, particularly in the current circumstances, escalating something sooner rather than later is probably the golden rule. If there's payment or supply problems, you want to be top of the priority list, and unfortunately the he who shouts loudest sometimes in the current circumstances will get that attention. It doesn't mean jumping into court or doing something that seems quite, I suppose, foreign to the relationship that you're trying to preserve. The sooner you start, the more gradually you can escalate an issue, and that helps to preserve that ongoing relationship. It rather sounds like I'm selling our services, but it does sometimes help to get somebody else outside of the relationship to help you escalate it, so that you can carry on that relationship, and essentially you're playing good cop, bad cop, and you can let somebody else deal with the issue that might be simmering in the background. And we often get involved helping clients for that very reason.
And what about the other area that you do a lot of work in is kind of product liability stuff? If companies and organisations are looking at sort of new products in connection with COVID-19, what sort of issues should they be thinking about there then?
Well, that raises a whole host of regulatory issues, and there may be companies that are looking to diversify. Now, they may be looking to diversify into something COVID-19 related, or it may just be that they see an opportunity or indeed a threat to their existing business and they know they need to diversify. I guess there's two particular issues there. One is insurance related and one is sort of regulatory compliance. On the insurance side, you just need to check that any new type of product will be covered by your existing policy. So you need to check that, and you may need to advise your insurer that you're changing to produce a new product so that is covered by your policy. And also because if there's any material increase of the risk of an insured event happening, you need the insurer to potentially be aware of that. Also, you may need to think about whether or not you might need a product recall policy in place. Most product liability insurance wouldn't cover product recall specifically. And lastly, I guess just to be aware that product policies tend to exclude unsuitability or failure to perform. So like, for instance, one can think of like a hand sanitizer or something that didn't maybe work the way it was supposed to, didn't protect somebody. So that wouldn't normally be covered. So there's a potential liability risk there. So those are some of the insurance questions. And then on the regulatory side, it's not possible really to go into all the regulatory sort of side of things. And there's basically just to be aware that whatever you're planning to manufacture, you need to understand what legislation underpins the regulation in that area, what guidance is available, and ensure that you comply with it. And there's quite often regulation both at UK and at EU level that you need to be aware of. PPE is one obvious example where there's a host of regulation and also now new guidance in the current circumstances both at UK and EU level to work out. Some very helpful guidance which provides a lot of input to people to understand what the legislation requires and what exemptions may be available. So it's a very complex area and it will depend on the type of product involved.
Great. Okay, thanks, Joanna. I'm going to move on now and ask Graham if he can cover some issues around about the property sector. So Graham's a partner in our property team, and obviously, Graham, the property sector has had huge challenges as a result of COVID-19. What's the reaction in the sector been, and how have they coped up until this point now that we're sort of reaching the end of the beginning, if you like?
Well, thank you, Morag. Hopefully you can hear me, yeah?
I can, yes.
Good. No technical issues. So, COVID-19 has obviously had a substantial impact for anyone in the commercial property sector, and I think we will all be aware of that. In the short term, I think the key theme for the property sector has been one of uncertainty. And for occupiers of commercial property, the challenges faced when vacating offices, shops, factories, hotels, warehouses have been significant. I think many of us will have felt that. But the challenges faced as we now start returning to these properties is perhaps going to be even greater. And obviously some of the things that Lynn has been setting out at the outset really start to impact on property occupiers. For investors in commercial property, it's a time of great uncertainty. There's pressure from the banks and from funders. There's discussions and negotiations with tenants, and there's widespread need for reassurance in the market. And so it's been no surprise that we're seeing quite a sort of level of paralysis in the property transactions. Investors are slow to spend when the market sentiment's unclear. Sellers are not bringing properties to market. Banks are slow to lend when they cannot understand what asset values are, and values are so much up in the air at the moment. And occupiers are obviously reconsidering their own requirements as they go forward in light of COVID-19. I think none of us would have imagined a few months ago that office occupiers in particular have been stunned perhaps by the realisation that so much can be done without any office premises at all. So there's obviously going to be a time to sort of rethink on that. But it's through lockdown, I suppose, taking us through to the current date, there was an immediate focus for businesses in terms of dealing with costs associated with properties. And that was in a situation where they were not going to be using their premises, and at a time when cash flow for businesses were projected to be declining steeply. The government were swift to act on this, and they had to be. Most commercial tenants in England, for example, would have faced paying their quarterly rents on the 25th of March, which was very shortly after lockdown. As such, tenants under English leases were immediately under pressure. So rates payable on commercial premises had also been had long been a sore point for occupiers, most notably in the retail sector. And again, that was something that quickly became a point of focus at the end of March. And so the UK government responded by passing legislation which stopped landlords from taking action to terminate leases for non-payment of rent. And that position remains in place and lasts until 30th June 2020. The Scottish Government quickly followed suit by extending the period for notice required to terminate Scottish leases for non-payment of rent out to 14 weeks, and the Scottish provisions will remain in place for the moment until 30th September. But in terms of rates, which I mentioned, there's also been a number of initiatives from the government, but the 12-month rate holiday for retail, leisure and hospitality businesses grabbed the headlines. The government wanted to take the pressure off. They wanted to create space for landlords and tenants to discuss the consequences of the emerging crisis, and they have been successful to that to a degree. But to be clear, nothing that the government has done has stopped rents falling due. There's no waiver of rent or any other obligations under commercial leases. But what they have done is to put in place measures to stop what they are calling aggressive landlords from making their commercial tenants homeless during a time of crisis. More recently, the government has bolstered that position by announcing that landlords cannot pursue winding up orders against tenants or serve statutory demands for recovery of debt with the reasons for non-payment right to COVID-19 issues. And so that briefly kind of brings us up to where we stand right at the minute.
And what about the future then? What does the future look like for the property sector, would you say? What are the key issues?
Well, as we're coming out of lockdown, which is where the focus now lies, we're at the beginning of the next stage of the crisis. And the next themes for the property sector might be sustainable recovery, but also unfreezing properties. And that comes with a number of practical issues. And from a practical point of view, getting back into properties will allow a great deal of estate management activity that's been on pause to recommence. So building surveys, valuations, rent reviews, maintenance and fit out, refurbishment, all that kind of stuff can restart. And there'll also be many new practical challenges coming to light in terms of operating buildings while maintaining compliance with health and
sorry, I'll just
safety
stop you a
requirements.
moment there, Graham. I think we've got another voice coming through. Can you hear that? If everyone can put themselves on mute, that'd be great. Thank you.
So yeah, just talking about obviously the sort of practical challenges of getting back into buildings. Take an example of offices. There's lots of health and safety requirements there, and there's also going to be teething problems ahead. In terms of property management, I think landlords will find management of common areas within buildings to be a particular challenge, and that will require them to scrutinise their occupational leases to ensure that they keep within the rules agreed with their tenants, but also for landlords to perhaps understand what costs relating to health and safety measures can be recharged to tenants. If you're bringing in enhanced cleaning rotas and sanitisation stations, new signage and increased numbers of people within the building management personnel, can you charge your tenants for that? From a legal perspective, what I expect to be seeing going forward is that commercial leases will be for shorter durations. I think they'll be more flexible in their terms, and that's all just reflecting the fact that tenants are going to be much more cautious in the sort of post-coronavirus era. We can also expect a great deal of legal time to be devoted to negotiation of COVID clauses and leases, and what I mean by that is there'll be a focus on abatement of rent during a period when a tenant cannot occupy a property. And at the moment, the vast majority of commercial leases will not cater for a rent holiday as a consequence of a pandemic. Whether landlords start to agree to these kind of clauses, that will be a commercial discussion, a commercial decision for landlords. In terms of the government response going forward, at this point, the question for the government is whether they can continue to support, continue the support that they've already given, and can they bring in additional support strategies as circumstances start to evolve. Landlords, for example, have been largely neglected when it comes to government support, and the Chancellor will today give an update on the furlough scheme for employees, but various property industry and retail sector bodies have been asking for a furlough scheme to be applied in a similar way to inactive properties, and that could see some level of government payment being made direct to landlords as a contribution towards rents payable on mothballed shops, restaurants and offices, etc. And obviously a main focus there might be the restaurant and leisure sector, where these businesses are likely to remain closed for some time yet. But the point's been made, the property sector is an ecosystem, and when tenants can't pay rent, that impacts on landlords, and it also impacts on their funders, and it also impacts on development and investment in the sector as well. So if you think about it, many landlords will be pension funds, and that also has an impact on all of us who might have an interest in those kinds of investments. But finally, as payments relating to property are cyclical, we can't take our eye off the calendar, and the next quarterly rent payment date due under most Scottish leases will be very soon, on the 28th of May, and in England it will be the 24th of June, which is just before the government's ban on termination of English leases comes to an end. So each of these dates will bring a renewed focus for landlords and pressure on tenants, and I guess the question has to be, what action, if any, is the government going to take in order to extend these protections that they've already put in place for tenants, and what's their plan going to be going forward?
So there's a lot there then to be thinking about. I guess on the kind of COVID-19 type clause, as you say, it'll depend on the commercials, and it may be that with less companies looking for city centre type offices, those that will have more of more leverage in negotiations than perhaps previously. So it'll be interesting to see how that develops, I think, won't it?
There'll be the market will be quieter for periods to come, so the tenants might have some leverage to start forming a new market norm in terms of what should be contained in leases. Yeah,
great, okay. Thank you, Graham. I'm going to pass now to Chris. Chris is a senior associate in our construction team, and the whole issue, of course, of construction sites and when they can open, when they have to close, the differences between Scotland and England has been a theme, really, of lockdown. What's your view, Chris, on when construction sites in Scotland might be able to open as we start to ease out of lockdown?
Yeah, so thanks, Mark. Yeah, the divergence between our countries of England and Scotland has become even more stark at the weekend after the latest government announcements, and certainly the construction sector highlights that divergence particularly starkly. So south of the border where we are right now is Boris Johnson says that he's encouraging the construction sector to go back if it can comply with the guidance on safety and welfare of people and with the law, and noting always the various constraints that have been explored in recent days about individuals, whether they can get to site, whether they have childcare obligations, etc. So the message south of the border is very much now open if possible, but that if possible is subject to considerable scrutiny. And a lot of Lynn's health and safety thoughts that she explored at the start of this call are key to those decisions. Meanwhile, here in Scotland, Nicola Sturgeon is saying no to any return to construction unless you're working on what they've been calling an essential site. Scotland's construction sector guidance is still requiring any construction work to fall within a certain number of essential subsectors which have been specified in that guidance. And even if an essential category applies to the work, only elements of the work which are actually essential are to be carried out, and that is to be interpreted as being elements that are supporting an aspect of the COVID-19 defence or are within some limited additional exceptions which were added to the latest amendment version of the guidance, such as renewables projects which are due to energise in the next 12 months. But preparations for enabling a return for Scottish construction are nevertheless ongoing. There's a restart working group which has been established and last met on the 8th of May, chaired by the Minister for Local Government, Housing and Planning. That group produced an updated set of site operating procedures and what's being called a restart plan, and apparently those are currently sitting with Health Protection Scotland for review and approval. No firm date was given for that group, but the Minister was quoted as saying construction would be one of the first to turn when law measures in Scotland were reviewed on the 28th of May. And that means, for a number of commentators, that the earliest that the Scottish Government and general return to construction to be the 1st of Now, Monday's official government update in relation to COVID-19 was following a small line, but took great care not to offer any specific dates for understandable reasons. The update stated that non-essential business sectors like construction, unless it's an essential construction like a hospital, need to remain closed unless and until we can all be clear how operations can be undertaken safely. The statement went on to say that the government will work with the sector and others to consider if it's possible to produce appropriate guidance on that specific point. But unless and until such guidance is issued, non-essential construction sites should stay closed. In terms of stories on the ground, though, we are nevertheless hearing of certain sites reopening or making certain final preparations to try and do so. And this is perhaps to be expected given that the main messaging continues to be in the form of non-mandatory guidance rather than law. We've had experience in recent days of contractors whose insurance have been telling them that despite their preparations, the insurers will not cover them if they return to work on a non-essential construction site because it's contrary to current guidance. So when considering reopening, contractors need to be conscious of the fact that their insurance contracts are separate to the construction contract, and it may well contain relevant terms tied to matters such as guidance, health and safety compliance, or good industry practice. Examples have also appeared in the last week of firms being asked to explain why some construction work is being carried out. There's been one publicised example this week where a government probe has been launched after residents across the road from the construction site contacted press when they saw builders carrying out work on what they deemed to be a non-essential construction site, apparently including instances of workers being spotted and pictured breaking social distancing rules. In that case, the contractors stated that they were aiming to work on a limited scope of works to mitigate the situation, but this is a key example which demonstrates that those who are going to be the first to return to construction sites may well find themselves having to defend their positions and reputations, and the potential for health and safety enforcement, which Lynn has highlighted, is what is looming large there. You've got to contrast that with the simple fact that a number of contractors may well have found themselves with limited scope for relief under their contracts, They may at the moment essentially just have the moral high ground, the furlough relief for wages for some of their employees and the goodwill of some of those employees and families as comfort, but that's all they've had. And even those that have found themselves entitled to certain relief under their contracts whilst restrictions are in place may find that responsibility for any further delays as soon as the guidance allows construction to start will swiftly shift back onto them.
Yeah. It's an unclear picture, really, isn't it? It's an area that's just going to continue to cause difficulties, I think, for quite some time.
Yes, I think so. It's a very much a watch this space.
Absolutely. Jen, I had promised you 10 minutes on what I obviously think as a fellow employment partner is the most interesting topic of all that we've covered today. I've now reduced you to 6 minutes. But obviously we're due an announcement on the job retention scheme this afternoon. So just to get your thoughts on that, and also the kind of issues that you're dealing with from an employment point of view in terms of people now being told they can return to work. If you want to pick up on those points, that would be great.
Okay, no problem at all. So everyone's kind of waiting with bated breath today to find out what the Chancellor is going to announce on the furlough scheme. I don't know when that's going to happen, but apparently he's going to be taking some urgent questions in Parliament on it around 12:30. So I don't know if he'll maybe make the announcement then or later, but for those of you who are interested in that, and I think that'll be most of you, will be doing an update once we've got that, and we'll send that round to our whole database. The current position on furlough is that it's live until the end of June. But the reports that have been circulating, and I do need to stress they're just reports and leaks, indicate that there will be an extension, so no cliff edge is what Rishi Sunak has said, although he has said it's unsustainable in the current model because we've got about a quarter of the UK's workforce on furlough at the moment, and the level of claims that have been made have been kind of eye-watering. It's effectively costing the same amount of money as the NHS at the moment. So we understand that there will likely be an extension, the report suggests, till end of September, but perhaps with a reduction of the subsidy to 60% of workers' pay, which I still think would be welcomed by employers because there are going to be so many different sort of dates for employers being in a position to return. Some of that will be sector specific, but some of that will just be business specific as well, depending on when their workload increases. So another kind of point that I'm quite interested in terms of the extension of the furlough scheme, which links into the health and safety issues that Lynn has been talking about, is if people are still being told to shield in line with public health guidance, or if they have children that are not allowed to go back to school because the schools haven't reopened, then could we still see an extension of the furlough scheme for those categories of people, even if it's not being extended indefinitely for the more traditional kind of business furlough as we've described it. So we'll see what comes out, but I think the general view is that it will be extended. It just won't be as generous as it is at the moment. Very brief overview of issues on return to work, and highlight the need for kind of employees around health and safety risk assessments that you're doing, and I do think that communication is going to be key to alleviating a number of concerns that employees have got. It's very likely that they will still have concerns, whether it relates to their own personal health, people that they're living with, or just generally anxious about travelling into work or being at work. There will be different legal risks that arise from those different kind of reasons for being worried or perhaps even refusing to come into work. The main thing that I would highlight to you is that there's protection under the Employment Rights Act for anybody who refuses to come into work or kind of leaves work in circumstances where they think there's a serious and imminent danger to health and safety. I have never used this provision of the Employment Rights Act in my whole career. I don't think you have either, Morag. because it's so rare. But I think this is going to be its time. It's time to be in the spotlight, because you can just imagine some employees saying, either relying on the government guidance or just my general belief that you haven't got the right health and safety measures in place, or I have to get the bus to work, and that of itself is going to create a serious and imminent danger for me or my family members. So in those circumstances where they've got that reasonable belief, they can't suffer a detriment or a dismissal as a result of that. So that will create risks with any employers who are perhaps looking to take action or discipline or dismiss people for refusing to come into work. So I would just highlight that hesitancy or reluctance or indeed refusal to come into work is a real risk area, and something that as a team we'll be speaking about a lot with our clients, and no doubt touching on future webinars. The other thing to note, which again we've touched on in other webinars, is that employers are now looking at collective redundancy obligations, changes to terms and conditions. Just be really careful on all of that. I'm sure a number of you will be familiar with the processes, but the key thing to note is that where there's 20 or more proposed redundancies, collective obligations are triggered, and if you don't get that right, that can be a protective award of 90 days for each affected employee. So it's really high risk, high value, and redundancies means more than just I'm being made redundant because I have no work. It can be dismissals and re-engagements. It can be voluntary redundancies. So I would just sound a kind of note of extra caution on that. And finally, because it's 12 o'clock and I've only got 10 seconds left, just to say that we're getting a number of queries from clients about sort of restarting what we would probably call the business as usual processes. So how do you, when you're getting people back into the workplace, revive either disciplinary, performance, capability issues? Not easy, but what I would say is we come back to our old friend, the reasonableness test. So, of course, you can restart procedures and address issues even if they've come to light during furlough or whatever, but just be careful and reasonable in your approach to it. And if you are dealing with capability issues, make sure you get up-to-date medical advice, because what you had pre-COVID is perhaps not going to be useful and meaningful to you now. And with that, I'll hand back to you.
Thanks, Jen. Well done. There has been recent ACAS guidance as well published on dealing with disciplinary and grievance issues in light of COVID-19, so something perhaps just for you to take a look at if that's an issue for your business. I hope you found that session helpful this afternoon. We'll obviously keep you up to date with any developments as and when they arise, particularly the job retention scheme update this afternoon. If you're not already signed up to receive our updates, if you just go onto the website, into the contact section, there's a bit there where you can subscribe for updates to make sure that you receive everything that's coming through. But thanks again for your time, and I hope you all have a great day. Take care now.
Thank you.